All right, I think we are all set up. Let me turn that off. And that. Okay. Good morning, everyone. We are here for a motion to dismiss in 25cv008160. It's Ms. Gates versus Fulton County and City of Atlanta. If I could have the appearances first for Ms. Gates and then the county, then the city.
Good morning, Your Honor. Wingo Smith, along with Jeff Lipowitz and Jimmy Hurt, who is with us via the Zoom.
Virtually, I see his name on there. Okay.
Good morning.
And good morning, Mr. Hurt. Will you guys be tag teaming, or what's the plan for working through Ms. Gates's presentation?
It'll be me presenting for Ms. Gates, Your Honor.
Great. And on behalf of the county?
Morning, Your Honor. Colin Dan Delaney from Smith, Gambrell, and Russell, along with AJ Rollins and our associate Marshall Hall.
Great. Good morning, Mr. Delaney. And on behalf of the city?
Good morning, Your Honor. Cheryl Ringer and also Chair Smith. I'm sorry. All
right. Good morning. So let me tell you where I understand we are, and then you guys can correct any procedural misunderstandings I have. And then I think we'll start with Mr. Delaney. It is a motion to dismiss filed by the county, although the city has moved pretty much in lockstep with the county. And I think the city is in some ways a secondary defendant because the county collects taxes on behalf of the city anyway. And so if it's a challenge to a tax collection, it's really a challenge or taking away an exemption. It's a challenge to an action that the county took. It just may have collateral effects on the city because the county is collecting taxes for the city. Is that a fair statement, Ms. Ringer? I noticed you're not sitting at the table, which is fine. You can be in the first row, but that the city is maybe a little more passively observing what plays out today.
Correct, Your Honor. And the city has not formally filed anything in respect to these actions.
Okay, got it. So this is actually the second of two cases that Mr. Smith and his legal team have brought. Both seek to be turned into class action lawsuits. This is the Gates matter, and we agreed as a group that working through the motion to dismiss in this case will give some clarity about what would happen to the other case as well. We've had a number of conversations about discovery and what ought to be provided before class certification or before we have a motion for summary judgment. I don't intend right now to convert this to a motion for summary judgment, but we'll see how the discussion goes today. But right now I'd be relying on the state of the record short of the affidavit that the county prepared. Ms. Gates lives at an address here in Atlanta in a property that her father purchased. He passed away, and Ms. Gates's mother then obtained full title to the property, and there was a homestead exemption in place through Peggy Gates's parents and her mother, Florine Gates in particular. Her mother passed away in 2018, and Peggy Gates is the administrator of her mother's estate. But I believe as of today, but more importantly, as of the time the lawsuit was brought, the property remains in Florine Gates's name. So we have someone who occupies but may not own and did not apply for a homestead exemption. That would be Peggy Gates, yet has benefited from the persistence of a homestead exemption that was obtained by someone who did own, occupy, and apply for it. And we're working through whether the county can retroactively say that was not proper, that the homestead exemption is in place. We are not reassessing the value of the property. We're not saying the home is worth more or less, but we are removing from a mathematical calculation a figure that it sounds like reduced the tax burden to zero, but it really doesn't matter what the final tax burden is. It's that subtraction, and the county is saying we are allowed to cancel the subtraction that occurred, and whatever is left is a tax obligation that Ms. Gates owes for 3 years. There's a statute of limitations, and it sounds like the county has made very plain, I don't know if it was in a legal filing, or at least it was an explicit communication from counsel for the county to counsel for Ms. Gates. And this, I think, makes one of the declaratory judgment pieces moot. The county will not be seeking to collect for 2020 or 2019. So we're dealing with 21, 22, 23, 3 years back in time, saying the subtraction that occurred was incorrect because there wasn't a proper homestead exemption in place. We are lifting that homestead exemption. And so, Ms. Gates, you owe this money. And there's a challenge to that. The lawyers for Ms. Gates seek to turn it into a class. But where the county has pushed back is saying there's nothing illegal about correcting this mistake that was a homestead exemption that should not have persisted beyond the death of Florine Gates. And for there to be a homestead exemption in place on this parcel, Peggy Gates or someone who owns the property would have to apply for it. Query, and we'll explore this, who owns the property if it's still in the estate, and there's a statute I want to ask the county's attorney about that seems to address this. But I think procedurally that's where we are. Mr. Delaney, as the movant, I'll turn to you first. Do you agree that sort of structurally that's where we are?
Yes, Your Honor.
Okay. Mr. Smith, anything you want to add or subtract, since we're talking about subtraction? Not legally, but just sort of factually, that's where we are.
No, Your Honor, I think that factually that brings us up to speed today.
What is your response to my observation that your request for declaratory relief, which pops up in paragraph 63 of your complaint, that's moot now, given the county's representation, because they wouldn't be going back beyond 2021?
For us, Your Honor, we believe that would still be under the voluntary cessation. Making that declaration in itself does not bind the county to not change its mind once the litigation is completed.
Meaning the county's declaration that they won't pursue it?
Correct.
Okay. And
there's a question about the county's reasoning for why it wouldn't go back relates to the statute of limitations, which also involves the, roughly speaking, 280 something persons who they are seeking to remove from the potential class. I think there's gonna be a question that's gonna come up today about whether or not that statute of limitations, such as they presented, is one that actually applies. And if it doesn't, then I think we're left in a much grayer area in terms of what their authority would be or wouldn't be in that situation.
And your theory is, Mr. Smith, that there is a statute that places a statute of limitations on state authorities, but not local authorities. And so it's unclear that there is a bar on the county from going back to 1822 to say, hey, you haven't been paying for a while. Or am I misapprehending your?
No, the Court of Appeals is who said that the statute in question applied only to the state commissioner.
Well, but are you not invoking that in your?
Absolutely.
Okay, so you are saying that. You are saying Court of Appeals said it, but that's your argument, that there is in fact not, there doesn't appear to be statutorily a statute of limitations on the county's ability to go back in time to say this homestead exemption has been erroneous since 1921 and we're going to collect for
we agree
100 years.
The statute has to have a statute of limitations of some kind. That particular authority for the statute of limitations does not appear available to the county. What the true statute of limitations is not something that we know, and is also likely not relevant to this particular case and the other aspects of the case in terms of in the center of whether or not there's liability here or not.
Okay, got it. Well, Mr. Delaney, when you're ready, why don't we dive in?
Thank you, Your Honor. Good morning.
Good morning.
I'm Colin Dang Delaney from Smith, Gambrell & Russell on behalf of Fulton County. And it's evident that Your Honor's pretty familiar with the record already. So please, if I'm going over a point too long, tell me, move along. You understand the point.
I will nudge you if I feel nudging is necessary.
Please, Your Honor, please do. Excuse me, I'm feeling a little under the weather. I think I'm getting over it though.
Uh-oh, we'll stay there.
I'll stay here. I'll wear a mask if you would like, Your Honor.
Nope, I'm good.
Your Honor, in this proposed class action for a refund of property taxes, plaintiff Peggy Gates is alleging she was illegally assessed. The principal legal issue presented is whether the county has the authority to disallow the homestead exemption for prior tax years and assess additional taxes resulting from the disallowance, the subtraction issue that Your Honor mentioned in the opening. I must emphasize that for plaintiff Peggy Gates and for all of the members of the proposed class that she seeks to represent, we're speaking today about a homestead exemption they were not eligible for. Please bear that in mind.
Let me ask a question about that. I mentioned there was a statute that one of you, I think it was in your motion, flagged. It's 48-5-40. And this isn't meant to be a quiz. You're welcome to look it up. In fact, I'm going to get it up on my screen as well, so that I know you didn't make it up and it really says what it says.
48, I happened to turn to the very page, 48-5-40.
3D. And I think that says, but let me get my version. I said my version, a version, should be the same as yours, up on my screen. Okay, so 48-5-40 3D talks about the children of deceased parents who occupy the homestead of their parents. That statutory provision means that Ms. Gates, Peggy Gates, so we're clear, Peggy Gates could apply for a homestead exemption, and if she did and all her other papers were in order, she could obtain that exemption even though the property might still be working its way through probate.
Assuming she is an heir of the parent, yes.
Okay.
That's my understanding, Your Honor.
Okay. It doesn't mean, 3D doesn't mean automatically that homestead exemption that Florine had transfers to her child who occupies the home to which Florine had full title. So again, she owned, she occupied, and she applied, or her husband did.
Yes.
So she's got it. 3D doesn't say that exemption naturally flows to. It simply says, should Peggy have applied upon her mother's death, even though, and she occupied
Yes.
the property, which she did, she could get that exemption sooner than the often interminable delay of that property working its way through probate.
As long as she had an ownership interest in the property by virtue of being an heir.
Right.
Yes.
Okay. Understood.
That's the own piece of.
Right. Right. And the reason why 3D exists is because own is a little tentative at that juncture because the house hasn't gone through probate, and it might turn out that during probate that the General Motors credit division ends up owning the property because of some debts that aren't extinguishable or something.
That, or hypothetically, Florine Gates could have donated the property to Spelman College.
There you go. And there it goes. But the facts of this case are that Peggy Gates did not apply for the exemption.
Correct.
The county's position is you couldn't have obtained one if you applied. It's that you didn't apply and you sailed forward under the wrongful. I don't at any point mean to suggest that Peggy Gates willfully or intentionally or knowingly did anything sneaky to avoid tax liabilities. It sounds like this was an unwitting situation, although it was eventually brought to her daughter's attention, and doesn't sound like they applied right away. They went and did some other things. Neither here nor there. Peggy Gates could have applied, and assuming the ownership piece was clear enough, obtained the exemption, but she didn't.
Correct.
And the county is going back in her situation, and potentially many others, says Mr. Smith, saying these weren't proper exemptions, and you now are liable for the tax obligation if we correct the math. Not that we reassess, but we correct the math.
Correct, Your Honor.
Okay. So then 3D is not the magic bullet for Ms. Gates, where she could say, no, the exemption magically transferred to me upon my mother's passing.
Correct, Your Honor.
Okay, thank you.
Your Honor, my adversaries have found fairly sympathetic plaintiffs to be their clients and
They're
proposed
smart
class-
adversaries.
They are.
It's not a tax dodge in China that they picked as their client.
That's correct, Your Honor, nor a Bitcoin billionaire.
Right.
And I've never met the plaintiff. I'm sure she's a lovely person and a good citizen, but not all taxpayers who are in the situation of being assessed additional taxes as a result of even the retrospective removal of homestead exemptions are as sympathetic as the plaintiff in this case. There could be innocent errors, but there could also be outright tax fraud.
You referenced, and I don't know if it was because your legal team has discovered it or it was a hypothetical, a reasonable one, where person X applies for the homestead exemption to reduce a tax burden, but person X never intended to occupy. I own it, and I've applied for it, but it's a rental property, and I just want to pay as few taxes as possible. And I actually own 19 homes in this part of town, and I got a homestead exemption on each of them, and somehow the county didn't notice that Fred Smith, and maybe with a name like Fred Smith, they would think there are just that many Fred Smiths. But that you referenced that. Did your team run into those scenarios, or it's just likely that in the group of however many hundreds this applies to, there are folks who it's not inadvertence, it was purposeful and deceptive?
We definitely ran into what we would consider badges of tax fraud here. And I'll give Your Honor a concrete example, one that hits a little close to home. In the motion to exclude in the related Garrett case, when we went through the list of people for whom, taxpayers for whom the look back went too far back, if you will, when we went back more than 3 years, we found an example of a taxpayer who owns 2 units in my Midtown condo building. The address jumped off the page at me. And he combined the 2 units and undoubtedly renovated them, because who needs 2 kitchens? And at some point after having lived there, he moved to New York and puts the property up on the rental market. And at that point, he's not in continuous occupancy. He should not be entitled to a homestead, but he doesn't tell the county. And so he's sitting there with it for some number of years. And because the look back went too far back, we're in the middle of processing a refund for that taxpayer.
When you say the look back, meaning the county went forward and dinged this individual for, I'll make the number up, 7 years of you underpaid because there was a subtraction, there shouldn't have been. And now the county is realizing, oops, we really only should go back 3. Too bad we didn't catch it earlier. Those 4, they're on us. And so we made you pay 7 years worth. We have to refund 4 of those 7 years of assessments that we sent you.
That's a hypothetical, but that captures the point, Your Honor. Yes.
Okay.
The real issue is actually very small. The Board of Assessors was looking back 3 years from the event when they're disallowing the exemption. And on our reading of the statutes, the statute of limitations, what they should have been doing was looking back 3 years from the date the return was due. And property tax returns are all due on April 1st. So there's like a 3-month window when we
Got it. But it still is so they weren't going back more than 3 years. The assessors were always going back only 3 years, but it might have been 3 years and a couple months.
Just a little timing gap.
Got it. And so your example of the Midtown condo, it could have been 5 years that this person was misusing the exemption, but he was only ever going to be liable for 3 of those years. And it should have been 3 from April 1 back and not maybe from September back or something.
Yes, Your Honor. And just for completeness, the only situation that goes outside what you've just described is taxpayers who voluntarily self-report and say, oh, I had this homestead exemption when I shouldn't have.
Yeah.
And please take it away from me and bill me for additional tax. We have taxpayers who ask us to tax them. And
I bet that's a small group.
it's a small group, Your Honor, and most of them come from Florida because in Florida, claiming a homestead exemption when you shouldn't is a crime.
Oh,
And they come in and they tell us, please tax me.
we are anxious to pay off all our dues. Okay.
Indeed. We found an example of that. A couple who had a property in College Park or someplace like that. They moved to Fort Lauderdale and came in and said, tax me going back 7 years.
Okay.
So,
Yeah, with the taxpayers' agreement, you can go back that far.
yes,
Okay.
because essentially they're waiving the statute of limitations defense. Your Honor, the reason Ms. Gates got the additional bills, got billed for the additional taxes was that, as Your Honor touched on, but I want to highlight this point. For those first 2 years, 2019 and 2020, after her mother's death in January of 2018, the property had what is known in the trade, if you will, as the max 70 exemption. There are exemptions that are based on age. And her mother had achieved the age of over 70 years, and so she was entitled to that. Our calculation is that on January 1st, 2019, when the plaintiff would have been eligible had she applied, she was still in her mid-60s. So there would have been a slight difference in the amount of the homestead exemption. As Your Honor noted, the result, because the max 70 was so large relative to the assessed value of the property, is that the plaintiff was actually paying, or the property, whoever was paying the property taxes on the property was actually paying zero in Fulton County taxes and about $45 in City of Atlanta taxes.
My tax bill was different.
So was mine, Your Honor.
Yeah. Huh. Okay.
But that's the law. Those are the exemptions. We understand that. If Florine Gates had lived a couple of years longer, that's what she would have been entitled to. And if Peggy Gates had applied, she would have been entitled to something as long as she had shown her ownership interest in the property. It just would not have been the same.
Sure. The math that the county is seeking to impose here or has imposed is what the tax obligation would be with no homestead exemption and not, well, there's a differential between your mother's and yours because you're younger, et cetera. You just owe that differential. Because there was no application, there is not an approach, the county's approach is not, well, we're going to find this middle ground and that's because you meant to apply, but you didn't think you need to, or you just never thought of it. We're going to give you your homestead exemption and charge you the difference between mom's and yours. That's not what is being pursued here.
Correct.
Okay.
Your Honor, the plaintiff in this case, in the initial complaint, was not entirely forthcoming about some of the facts, such as identifying the property. And that's why when we initially moved to dismiss, we presented it as a motion to dismiss or for summary judgment because we were bringing in these additional facts so that we would have a concrete set of facts to look at. So we figured out where the plaintiff's property was or what
So the
plaintiff's
initial complaint, I can pull it up in a minute, said that Peggy Gates lives on 123 Main Street and she didn't live there? Or it just said she is an aggrieved Fulton County taxpayer. We're not telling you where.
the latter.
Okay. It probably didn't say we're not telling you. It just didn't say here's where she lives.
Correct, Your Honor.
Okay.
Yes.
But we know where she lives.
But we know where she lives. We
Okay.
figured it out. As Your Honor mentioned, the plaintiff's father bought the property in around 1974. The property is 412 Holly Street. It's about 5 miles west of the courthouse near Bankhead. Mr. Gates, Robert Churcher Gates, was the sole title holder for almost 30 years. We believe he died sometime in the late 90s, and his estate wasn't probated until several years after his death. Following the appointment of the administrator, title passed to his heirs at law. Apparently, he died intestate, and that was a 1/3 interest to his wife, and then the remaining interest divided, I think it's per stirpes, if I go back to trusts and estates class, to his children. when the property went through probate, the children, I believe, including Peggy Gates, the plaintiff in this case, all quitclaimed into their mother. So the Florine Harris Gates winds up again with sole title, which she holds until her death in January of 2018. Because at some point she satisfied the requirements of own, occupy, and apply, she enjoyed the homestead until her death.
She applied, the records show that she applied, or the application of her husband, the exemption that he had obtained carried over to her?
I don't know the answer to Your Honor's question, and I don't want to speak when I shouldn't. The way it works, it should have been a new application in her mother's own name because the exemptions are personal. They don't run with the land.
So it's possible that Florine Gates was benefiting from the exemption when she shouldn't have because she didn't know to or didn't think to apply. You're not saying that, I understand, and it's really not an issue here. But you don't know the answer to whether she had applied. And so the plaintiff is just assuming that there was a valid homestead exemption that might carry over.
We know there was one because we can see it on the notices of assessment.
But it could be Mr. Gates's, in which case that would have extinguished upon his death unless someone, the occupant who owned it, which eventually was Florine because of the quit claims, she would have needed to apply.
Yes, Your Honor, it could have been. That's not in the record.
Okay.
But I'm assuming that it was Florine Harris Gates's exemption duly applied for during the period when she owned and occupied.
Okay.
Your Honor, our opening brief gives you chapter and verse on Georgia Code and the county and city ordinances that create the homestead exemptions. Now, a lot of this comes from the state code, but really the real value today is in county and city exemptions. That's what really makes a difference to taxpayers like...
Especially if you live in Atlanta.
Yes, taxpayers like you and me, Your Honor. I'm not going to belabor the point of what a homestead is, who's entitled to one, what effect it has on taxes, how you apply, or how the initial and final determination is made. That's all covered in our briefs. What I would like to do, if I may approach, Your Honor.
Sure, as long as you got something for Mr. Smith.
I absolutely do. You can have an extra for my colleague.
Thank you. Do you have one for Ms. Niles, or does that mean you're going to take it from your
I'm
colleague?
going to have to take a...
All right. Sorry, colleague.
End it up. Thank you. Your Honor, these are a few select passages of the laws that govern today, starting with 48.549A. This establishes who is the initial and final determiner, if you will, of eligibility for the homestead, and that is the County Board of Assessors. The code section that requires an owner-occupier to apply for a homestead is 48.545A1. That statute also provides that once granted, a homestead exemption automatically renews from year to year, so long as the owner continuously occupies the residence as a homestead. Now, notice the careful wording there. The exemption doesn't attach to the property and run with the land. It's personal to the owner-occupier.
Which statute are you on?
I'm on 48.545A1. I didn't want to have too many sheets in my handout, so I didn't print this one.
Oh, okay. As I said, I didn't see
important
it
one I
in
left
there.
out here.
Okay. But I get the point that it doesn't run with the land. It is unique or specific to the applicant.
Yes, Your Honor. And so when the owner-occupier dies, the automatic renewal doesn't carry over anymore because the owner is not still in continuous occupancy of the home. The new owner, be it an heir or a transferee, needs to apply in their own name.
Do you agree with that, Mr. Smith?
That the subsequent owner would need to file for a new exemption, Your
We
Honor?
need to apply, that it doesn't carry over. You're my son, I die, you and I were sharing the house. The exemption doesn't carry over to you. It's specific to the applicant and not to the property. Is that a legal dispute we're having, or you agree that's how it works?
No, that's our understanding, is that typically the next person would apply for the exemption.
Typically, or to get an exemption, you must apply.
In Ms. Gates's case, for certain, I am not sure how that works when people are joint owners with right of survivorship.
Understood. And I didn't mean to muddy it, but it would be if I own the property and you're living there, I pass, it was in my name, you're occupying, it's going to you, that's what my will says, you would have to apply for an exemption. I can't bequeath you my exemption. You can't point to the one I posted on the wall. You'd need to apply for your own.
Yes, Your Honor, we agree with that.
Okay.
Your Honor, another set of laws create the framework for what played out here and ultimately led to the additional taxes that the plaintiff paid and wants refunded. And I will pick up on a comment that Your Honor mentioned at the top of the morning. We're not saying that the plaintiff intentionally took advantage of any laws here, but some members of the proposed class did. Think of taxpayers claiming homesteads in multiple counties or multiple states, and think of that owner of those 2 units in my building in Midtown who's renting it out while he lives in New York. Your Honor, back in the day, before the era of boards of tax assessors with professional year-round staff and computer-assisted mass appraisal systems, the law required taxpayers to return their property for taxation every year. This functions like an income tax return, familiar to most of us, one on which we all self-report our income from various sources. We claim deductions, we claim exemptions, and we claim credits and then calculate the taxes we think are owed. On a property tax return, you self-report the property you own, assert its proper value that you think is the fair market value, you claim exemptions, and you basically say to the tax commissioner, tax me accordingly. These laws are still on the books, and I'll confess, Your Honor, I'd been a Georgia lawyer and a Fulton County taxpayer for almost 2 decades before I started representing the county and came to learn about these laws. Almost no one still does this today. You might do it for commercial property, but residential owners almost never do it.
So if I sent in a return and said, my house is worth 200 grand, and here's what I'm willing to pay, that just would then create an issue for the county and me to work through?
Yes.
Because my return would be pretty darn different from what they're trying to squeeze out of me.
Correct, Your Honor. We do see it, gadflies, if you will.
Yeah, sort of a
Maybe
sovereign citizen-y thing.
some of those, and some
Okay.
maybe retired lawyers who know what to do.
But you don't, you're not, I mean, we should broadcast this. If I send in a return with my chosen number, that doesn't control. Like, oh, McBurney sent in, he's going to pay.
$10.
Exactly. Or, yeah, $10, $45, whatever Ms. Gates had to pay.
You're right, Your Honor. It does happen. People do file property tax returns even today, but it's very few. But they still will go through the process of being assessed by the Board of Assessors, opportunity to appeal, and so forth. Now, under these laws, you're required to return the value of your property to the tax commissioner every year. That's 48,515. And if you benefit from a homestead, you're also required to report the amount of the homestead that you're claiming for that year. That's 48,550 and 50.1. Taxpayers have to sign their returns under oath, like an income tax return. And in terms of the reporting period, the tax commissioner opens his books to receive returns on January 1st and closes the books on April 1st, making April 1st the deadline to return your property every year. That's 48,518. Then what happens? Under the authority conferred and the duty created by 48,299A, and that's the next statute in my handout, the County Board of Assessors is charged with diligently investigating and inquiring into all the property in the county to ensure that the proper return of property for taxation. The assessors must investigate to determine the value of any property upon which for any reason all taxes due have not been paid. And the board shall assess against the owner or the property, whoever they can figure out, whoever they can find, the full amount of taxes which has accrued and which may not have been paid at any time within the applicable statute of limitations. That's an important reference because, as Your Honor already touched on, the plaintiff doesn't have an answer for what at any time within the statute of limitations refers to. We do. As applied to the situation here, the full amount of taxes due means the full amount of taxes that are due when only those exemptions for which the taxpayer is eligible are applied. When you have an exemption in place that the taxpayer is not eligible for, then the full amount of the taxes that are due is not being billed. And because it's not being billed, of course, it's not being paid. That shortfall is what 299A directs the county to go get. And the way.
And how does 299A survive the collision with 303?
There's no collision at all, Your Honor.
They just pass in the night, they wave at each other, and everyone's happy.
Because they're addressing different things.
Okay, you're going to get there.
I am.
Okay,
I promise.
I bet you are.
The way that the county ensures that the full amount of taxes actually due are paid is that we disallow the exemption that the taxpayer wrongly claimed and bill for the additional taxes. That's what happened here. Well, you may be wondering, what happens when the taxpayer doesn't return the property, like so few of us do? The law has an answer for that.
That's 20.
That's exactly, Your Honor, the next one in my handout, 48520A1. If the taxpayer returned or paid taxes in the preceding year, but fails to return the property for taxation in the current year as required by the law, the taxpayer is legally deemed to have returned the property for taxation at the same value as the last year and claiming the same exemptions. And that's where we run into the situation that we have here.
So the passive taxpayer, which represents 99% of all the taxpayers in Fulton, it's just whatever happened last year is what carries over to this year, unless there's been a reassessment, which is not action on the taxpayer's part, but periodically our home values, they tend to seemingly only go up. There's a new assessment and then our bill looks different from the year before.
Yes, Your Honor.
Assuming there's no change in the millage rate.
That's right, or assuming there's no what we call growth, which would affect how the county values the property. Your Honor is exactly right. When you get to the next tax year, if you aren't doing anything, you're basically saying, tax me just like you did last year. And
Including carry over my exemptions. Everything's good. I still own and occupy this place for which I applied for the exemption.
Correct. Now, there are good policy reasons for this. It surely saves taxpayers and the county a tremendous amount of paperwork every year as compared to a system where we've got 300-something thousand residential property owners claiming homestead exemptions every year. That would be a tremendous burden on the county to do. And so what the law has done here is created a presumption everything's still the same, except taxpayers are getting older, they may be qualified for something else. When we take the applications, we ask for your birth date so that we can calculate that. And there's no issue with the county having done that correctly here. Some taxpayers are going to benefit from this structure, as the plaintiff did here. That Max 70 exemption for 2019 and 20, it's on that property and we're not trying to take it away. And to speak to something Your Honor mentioned earlier, we've done this as a matter of record. There is a stipulation filed on the docket in this case. We're not going back to 2019 and 2020. But some taxpayers do lurk behind this framework and take unfair advantage, waiting to see if an audit will ever catch up. Think of the owner-occupier who turns their home into an Airbnb, or my neighbor in my condo who's moved to New York and is renting out the combined units. If he doesn't tell the county that he's moved away and has a rental tenant, this framework of laws is deeming him to have claimed the same homestead exemption he was entitled to before he moved away, even though it's now on the rental market. And the law is deeming him to have filed false returns every year. And that's what we're focused on, is finding those instances.
Is what happened with Ms. Gates, meaning the county discovering, whoops, there's an exemption that ought not to apply here because it wasn't applied for by the current occupant. Is that a relatively new effort that the county has been making, or is what's new that Mr. Smith and his team got involved to say, this has been going on for too long, well-meaning taxpayers who just didn't know better are getting socked late in their life with a bill that's sort of an unwelcome inheritance from what was a transition from one generation to the next?
I don't know the answer to when this process of, there is a vendor, the plaintiffs allege this in the complaint, there's a vendor who does an audit or a review by checking public records about deaths and so forth. That's, we believe, what happened here, not necessarily in the case of the other two plaintiffs in Garrett, but I believe in Gates, that's what happened. The vendor found the death record, matched it to the property owner and said, well, it appears that
They flag that file, someone does the research to say, look at that, that is a Florine Gates exemption that persists, it ought not to, whoever's in there now has a tax bill.
correct. Well, there are a few steps before we actually get to the tax bill. And I'll depart from my notes for a moment and go back into the packet in front of Your Honor. What you can see here in the annual notice of assessment, this is for 2023. The last year that had a notice of assessment generated with Florine Gates's homestead exemption on it. And you can see in box B, we have the Florine Harris Gates is the record owner at the top. In box B, in the middle of the page, you can see homestead, yes. And I'll confess, Your Honor, I don't know what those codes stand for, HF.
No, but I know what yes means.
But I know what yes
She
means.
got a homestead exemption.
She did.
Yeah.
And then you can see the effect on the tax. We have the appraised value. And it looks like here in 2023, the assessors were increasing the 100% appraised value from 124,400 to 167,300. Then the old historical funkiness that we have in Georgia law of doing taxes based on the 40% assessed value comes in. It's in my opinion, the legislature doesn't ask me, it's an unnecessary complication, but there it is.
Right.
I think it goes back, Your Honor, to the days when what we would now consider a violation of the uniformity provision of the Constitution and of the statutes. The tax assessors in some counties would say, well, we've established what the 100% value on everybody is. And, well, commercial, they don't vote. So we're going to tax them at 60%. Residents vote. There are voters. So we're going to tax them at 20%. And we really are farmers, so we're going to tax them at 5%, right? You can't do that anymore. Right. So everybody's at 40%. The 40% assessed value we see there is 66,920. And then because the homestead exemption was worth so much, it essentially ate up all of the value. And that's how we get down to 0 Fulton taxes and $45 in estimated city taxes for that year. Now we come to, in the packet, what happened when the county realized that it appeared that the record owner was deceased. This gets flagged for the Board of Assessors in the review by the vendor, and we generate this notice of a homestead exemption review. And this was sent to the property. And we don't know what happened. We don't know if the plaintiff actually received it or what or how she reacted to it. But what we do know is that a second notice was sent about almost 2 months later, August 4th. And our records did not flag that anyone responded to this at all. Now, in response to our motion to dismiss, the plaintiff made a point, oh, her daughter went and visited a county tax office. And so we've gone back and we've checked the records, and what we have found is someone who would appear to be, based on her name and the date sort of matching, her daughter went to the county office. But what she did was she put her own name in. And of course, at this point, we don't know that it's Peggy Gates who's occupying and has some sort of ownership interest, we would think, because she's the child of the record owner. But The daughter also gave her own address, not the 412 Holly Street address. So we said, no one responded. I'll acknowledge that happened. We've tracked that down in our records. It doesn't line up, but it happened. So to the extent there was a response, I'll acknowledge that happened. Now, the issue does not get resolved, and so we come here to December 2023, and the Board of Assessors says, we don't know who's occupying this property. We don't know who owns any interest in this property. The record owner appears to have been deceased for 5 years, so we're going to remove the homestead exemption because as far as we can tell, we don't know if someone who owns is occupying, and certainly we know no one has applied. So we give notice that the exemption is going to be removed, and crucially, we also give notice that you can appeal. Yet again, nothing happens. And so then in the packet, Your Honor, we have the 2024 notice of assessment. And you can see here, still the same record owner, property box B, homestead exemption, no, we can all understand that. And you can see the effect that it has on the estimated taxes.
What grounds to appeal would someone in Peggy Gates's position have had other than I'm just calling upon your good graces? I didn't do anything intentionally. If I had known I needed to apply, I would have applied, and maybe someone can exercise that discretion. But in terms of a legal basis to appeal, what would there have been? I'm glad that that right was flagged very clearly in that letter.
We have to, Your Honor. The Maroni case requires us to.
Well, way to follow the law. But I'm trying to think of, because you said, look, she could even appeal. But what would the appeal have been? Oops.
I think the grounds would have been oops.
Yeah.
And there may have been a conversation with the Board of Assessors staff to resolve that. And as a matter of fact, Your Honor, in response to this notice, this is somewhat outside the record, but more than somewhat outside the record, it is outside the record. The plaintiff engaged counsel, I think it's legal aid, and she did appeal the 2024 notice of assessment. She appealed on value, which went to the Board of Equalization, and I think she prevailed and got the value reduced. Then there was a separate appeal based on denial of the homestead for 2024. And we are in the process right now of getting that worked out. The appeal languished, it just didn't get addressed. It may have been an issue with the assessors didn't realize that it had to go to the Board of Equalization, but the long and the short of it is that is getting through the process of being resolved right now.
Okay. But that's with legal aid as Ms. Gates's lawyers?
Yes.
Okay.
Your Honor, the assessor's power, authority, and duty to do this, to remove homestead exemptions, well, actually, the removal of homestead exemptions is not time limited. That's probably a finer point than we need to make. It's the assessment of additional taxes that is time limited, and that's in the statute that we looked at earlier in 299A. Our case, Your Honor, is that the statute of limitations appears in 48-49B, and that is the next item in my packet of handouts. Wherein in 49B, it says the amount of any tax imposed by this title shall be assessed within 3 years after the return or report was filed. And then there's some things to make it easy. They say, well, if you filed your return early, we're just going to deem it to have been filed on the date it was due. Although Chapter 2 of Title 48 deals principally with the collection of state taxes by the State Revenue Commissioner, 49B, imposing this period of limitations, is express in stating that it applies to taxes imposed by this title, meaning all of Title 48 of the Georgia Code, including Title 48, Chapter 5, which is where you find county and city property taxes of the sort that we're talking about here. Your Honor, you've already mentioned that the plaintiffs contend that 49B does not apply to the taxes that are at issue here. For that proposition, they rely on Fayette County Board of Assessors versus Georgia Utilities Company, Court of Appeals, 1988, arguing that 48249B applies only to the state revenue commissioner. So the limitations period that's there only applies to state taxes. That's not what that case decides. What that case decided was the interpretation of a provision of that code section that no longer exists, that I think already no longer existed when the Court of Appeals decided it in 1988 because there were major revisions to the tax code in 1985. The provision that no longer exists, that was held to apply only to the state revenue commissioner, was a law that permitted the reassessment of property after the fact. And it makes sense that that would only apply to the state revenue commissioner, part of which there are vestiges of this that still appear in 48249, not this reassessment provision, I don't believe. But it has long been the law in Georgia for decades that county boards of assessors cannot do a second assessment or reassessment of a property for taxation once they've already done it in the first instance. That's not the issue here. We can see, going back to the notices of assessment and comparing 2023 to 2024, when you remove the homestead, the math changes, but the assessment does not.
It's the subtraction.
It's the subtraction. Now, in the complaint in this case, and in the Garrett case, the initial complaint, and I believe the amended complaint too, they were seeming to make a case about reassessments. That is not the case that they're making here today in opposition to our motion to dismiss. So to the extent that that ever was their case, they've abandoned it. Your Honor, if the limitations period that we see here in 48249B doesn't apply to county property taxes, what does? Pointedly, what statute of limitations is 485-299A referring to? The plaintiff does not have an answer to that question. On their absurd construction, there is no limitations period for the collection of county taxes. And 299A's reference to the applicable statute of limitations refers to nothing. Your Honor, that's silly. And it cuts against the plaintiff's interest because it means we could go back forever. We could go back to 2020, 2019. We could go back to World War II or 1921, as Your Honor suggested. Let's pause here and think about what this means, this 3-year limitations period. The legislature has determined that that's how long it's fair to afford counties the time to audit returns and to disallow wrongfully claimed exemptions. Once you get to the 3 years, the legislature has determined the taxpayer's interest in finality becomes more important. That's why the result flips. And on this, Your Honor, we have authority squarely on point from right here in Fulton County. It's Harper versus Davis, Georgia Supreme Court, 1944. In that case, the taxpayer had 3 buildings in, I believe it was College Park. One of which she lived in, one had been a living space, but it was converted into storage for the belongings of soldiers fighting World War II. And the third was a garage with an apartment over it. The taxpayer claimed a homestead exemption on all 3 structures. The exemption was initially allowed by the tax commissioner, who had a role in approving homesteads back in those days, does not today, by virtue of something Dr. Ferdinand essentially stipulated to relative to the Board of Assessors. In the Harper versus Davis case, the Board of Assessors caught on in 1943 and disallowed the claimed homestead exemption going back to prior tax years, 1942 and 1941, even though by the time the board acted in 1943, the taxes had been paid. And what that gets at is that law about you can't do reassessments. Okay, Georgia law has for years been, for decades, Georgia law has been that once the assessors make the assessment and then the taxpayer pays, the taxpayer's interest in finality becomes more important and the assessors can't do a reassessment. Now that's different from a situation where you're dealing with appeals. If a taxpayer appeals to the Board of Equalization, for example, the assessors can, and frequently do, happen to our clients, come in and say, well, we think it's actually higher. And then you litigate that through the Board of Equalization and ultimately to Superior Court. In this case, Harper versus Davis, the taxpayer argued you can't go back to those prior tax years, disallow my claimed exemption, and collect the additional taxes. That's the exact result the plaintiffs are arguing for today, albeit under a different theory. The Georgia Supreme Court rejected the taxpayer's argument. In Harper versus Davis case, they were citing Code Section 92-6913. Well, the language will look familiar, and my code book tells me that's the same statute as became 485299A, the statute on which we rely today. There, the court held that it was the duty of the assessors to ensure that the correct amount of tax is paid, and if that means disallowing an improperly claimed homestead exemption even years after, so be it. The court also relied on another code section, 89-903, which today appears in 4565. And it basically says there's no estoppel against the sovereign. They were trying to make an argument, well, you've received these taxes with my wrongly claimed exemption, you're stopped to go back and collect more. And the point that the Supreme Court came to is there's no estoppel against the sovereign. This is still good law today, Your Honor. Now, the plaintiff in the brief complains that there aren't enough facts in this case to tell if it still applies, to see if it really applies to the situation we have. I don't know what more facts you need. Now, sure, it's a 1944 opinion and it's not written in the way a modern Supreme Court opinion would be written, but it's still good law. The plaintiff, in an effort to distinguish that case, points to the fact that the tax commissioner, rather than the Board of Assessors, was the one who initially conditionally approved the exemption in 1941 and 1942 before the assessors finally disallowed it.
Right, that in Harper, there actually wasn't ultimately an approved assessment. They were going, that's how the plaintiff cast the case. I haven't
Yes.
read the opinion. I've read the competing interpretations and applications of the opinion. But what Ms. Gates's lawyers say is Harper is distinguishable because there actually wasn't ever an assessment. I mean, there was a preliminary one, but the ultimate decider of assessments rejected the assessment. And so they were simply making a correction to a non-final assessment. Whereas here, there was a very final assessment. And so Harper doesn't give a green light to reach back and reassess. One response is, we're not reassessing anything.
Yes.
This is not a reassessment, and I get that. But I'm also understanding the clashing interpretations of Harper. It's not quite on all fours for this case because of the structure back then, the administrative flow. It may have felt like a very final assessment to, I don't know if the taxpayer is Harper or Davis, but to the
Davis was the commissioner.
Okay, so Harper's the taxpayer.
Yes.
And Harper may have thought this was pretty darn final and this is what I'm paying. And then wait, you guys switched it. You can't switch. Where's the finality for me? And the Supreme Court said, if there was a mistake made, it ought to be corrected and they should disallow the exemption.
That's right, Your Honor. And you have put your finger right on our differing interpretations, and what I will submit to the court today, Your Honor, is that nuance and how the system worked back then, which is no longer how it works, was not material to the decision that the Supreme Court came to in 1944. So now I'll come to the plaintiff's principal argument today. As in the related Garrett case, the plaintiff's argument has changed over time. In the initial pleadings, they were talking about retrospective disallowing of wrongly claimed exemptions as being tantamount to a reassessment. They are no longer arguing that. The theory as pled was once you pay the taxes, you can't be reassessed, or you can't have the exemption disallowed. In our motion, we pointed out the flaw in that theory. The flaw is that Mrs. Gates, as the taxpayer for 412 Holly Street, wasn't paying taxes. So she's not even a member of the class she seeks to represent, and this argument fell apart. The theory that they are now relying on is 485303. And this was Your Honor's question about, do these laws collide or do they pass in the night? And we submit they pass in the night, Your Honor. Plaintiff contends that 485303, which is the last statute in my packet, authorizes county boards of assessors to correct factual errors in their tax digest when discovered within 3 years, but only if the correction inures to the benefit of the taxpayer. According to plaintiff, this statute means that a wrongly claimed homestead exemption that the taxpayer isn't eligible for becomes in some manner vested, that they become entitled to enjoy it even though they're not entitled, even though they're not eligible for it. When something about the tax digest, it's unclear to me what happens. It's unclear to me from the plaintiff's argument if the taxpayer's right to enjoy a tax exemption that they're not eligible for becomes vested, can't become taken away when the state revenue commissioner approves the digest, or maybe it's the mere submission of the digest. Well, let's talk about what this means in practical terms.
Does the digest include exemptions, or does the digest have the assessed value for each piece of property?
I've litigated property tax class actions for Fulton County for 8 years, and I'll confess I've never seen the actual physical digest.
But doesn't that make a difference? Because if the digest only has the assessed value, then what's happening here would not change the digest, and it makes 303 not applicable because there's not a mistake in the digest. The digest would show that it was assessed at $167,300. And nothing that the county is doing here is saying you need to change that figure. The county is saying you got a subtraction that you shouldn't have, and we need to remove that. And so I think it's a important question, because if the digest is assessed value less any adjustments, and so what you actually owe, then this effort would be changing the digest, and we need to navigate what 303 means and what it does. But if the digest doesn't include exemptions, then not only do they pass in the night, they're not in the same ocean, because this case isn't affecting digest. I just don't know. I know I've heard of the tax digest, and the county commission likes to talk about it, but it never yields anything for the courts.
And Your Honor, I'll put it this way, it's not in the record in this case.
All right.
What the digest contains. It may contain information about both assessments and exemptions.
Okay.
I don't have that in front of me, Your Honor. But I will submit, I invite the court to think about what this means in practical terms. Because even on the plaintiff's theory of the case, before 303, we definitely had 3 years to go back and disallow wrongly claimed exemptions and bill for the resulting additional taxes to ensure that the full amount of tax properly due is being paid.
But then there was a bunch of tax reform that was meant to benefit taxpayers. And so I don't know that we ought to get into the legislative history, although plaintiff argues for that, about 303. And the thrust of that would be, sure, you can correct things, but you can't do anything that makes life more difficult for the taxpayer because we burden them so much already.
Yes, Your Honor. And what that is, that was part of a much larger reform of property tax laws. And I submit that the addition of subsection A to 303 is just a minor addition to the code. It's not some earth-shattering change. But what the plaintiff's theory of this case is that 303A was a dramatic change in the law.
Well, but whether it's dramatic or not, what the first sentence says is that the Board of Assessors can correct errors when discovered within 3 years. There's the magic number again. So people seem to get it that the statute of limitations is 3 years. And when it benefits the taxpayer. And I think Ms. Gates does win on the notion that this action did not benefit her.
But this statute speaks to factual errors. This is a legal error. She's claiming a law, or the property is benefiting from an exemption that they're not legally entitled to.
What's a factual error?
A factual error is incorrect information, erroneous information about the condition of the property, the objective characteristics of the property. It's what we call in the...
That's in the digest? Like they describe, it's a 2-story home with
The assessors definitely have all of that information. It's a tremendous amount of data that they have that they're continuously updating.
But this statute says you can correct factual, it does say factual errors in the tax digest, not in your vast trove of information about each piece of property in your county.
And
What's a factual error in a digest?
incorrect value that results from having bad information about the characteristics of the property.
So they realize it's actually a 19-story high-rise, and it did at one point used to be a 2-story home.
Doctor's office.
Yeah, and it's changed. They developed it in Scilly County. We never updated it, and so it really ought to be valued at $10 million and not $100,000. They could correct that, but then not drop a big old bill, tax bill, on Mr. or Ms. office building owner.
Correct.
For that year. Good
Yes.
next year. They just missed out for a few years.
That's exactly right.
Okay.
Now, the hypothetical that we're playing with here, Your Honor, is of course dramatic, but there are lots and lots of other much more minor errors in the county's information about characteristics of property that result in erroneous value information. From another case that I represent Fulton County on, we've got a taxpayer in Alpharetta who at some point the owner of the property finished the basement. And so, but the county was never informed that the basement was finished. So you've got 600 square feet of occupiable living space that's not in the data. And because it's not in the data, the way the computer-assisted mass appraisal system works is you get a bad number that is the output. And that bad number, understating the value of the property, is what goes in the digest.
Got it.
So
So
there-
actual error is that number because it's predicated on bad facts.
Yes.
Which is different, your contention is, from a legal error, which would be, and this is assuming exemptions go into the digest, because we don't even need to split these hairs about what type of error if exemptions are not in the digest, but we don't know that right now. So assuming they're in there, it is a legal error. It was not a legal exemption, and it shouldn't be in there. Okay.
And importantly, Your Honor, homestead exemptions are different from information about the characteristics of the property. And this goes back to all that Georgia law that we've seen for decades about assessors cannot reassess property after the taxes have been paid. What 303 does is it changes the timing of that and the condition that the taxes actually be paid to something that refers to the digest. What makes homestead exemptions different is that unlike property characteristics, which the assessor staff can go out and look at, and they can even, with proper permission, and go into the property and look around and say, well, this office building hasn't been finished, or it has been, and look at the interiors and aren't these amazing? Get the values right. Homestead exemptions start with self-reporting by the taxpayer. Going back to the point we were making earlier about the annual return. This is something that the taxpayer does where they come in every year or are deemed to come in every year and say, I'm entitled to this exemption, same one as I got last year, please tax me accordingly.
How is that different from your other case where maybe I should have, if I was doing a return, people don't report that this basement has turned into 600 square feet of occupiable space, and that I didn't do that. I didn't self-report that.
Well, you should have under the law because you're being deemed to have made your return the same as the prior year. So the year when you do that, you should be reporting that you've done something. The difference is a difference Georgia law has drawn for years, which is this something that the assessors are charged with the responsibility of going out and determining in the first instance, or is it more like personal property, which the taxpayer is charged with reporting as the beginning of the process? We're starting in a different place. Now, using choice language about what county officials were supposedly not doing their jobs or not doing their jobs quickly enough, the plaintiff is saying that the burden is entirely on the state to catch on, to check death records, to monitor rental listings or Airbnb postings, or to search auto registrations nationwide. Well, Your Honor, what if you die out of state? or at least, or even more so out of the country? Or what if something that's personal to the owner that only the owner can know occurs, such as you move to Florida and you retire, but you keep your Atlanta property because you still want to live here, or have a home here for when it's too hot or it's raining too much in South Florida. And Your Honor, what if we've got a far less sympathetic plaintiff than the plaintiff here? What if Jeff Bezos's mother owns a home in Buckhead and she dies and no one opens a probate and no one tells the assessors that the that the taxpayer is now deceased? Should Jeff Bezos get his mother's max 70 homestead exemption on that Buckhead property? No, that's not how the law works. The burden's on the taxpayer to not file false returns every year or do not be deemed to be filing false returns every year, claiming exemptions that they're not entitled to. The law puts the burden where it should be, on the taxpayer to be truthful and honest in the first instance. The rule the plaintiff advocates for would be an invitation to commit rampant tax fraud against the state, setting up a system that puts the onus on the government to catch on to fraudsters even, not people as sympathetic as Plaintiff Gates, but to fraudsters within a mere matter of months. And that's because of the timing of what happens with the digest. The digest is assembled and submitted to the state around the same time as we all receive our annual notice of assessment, so June. And before the tax commissioner can send out the bills, there has to be at least a conditional or a final approval of the digest by the state revenue commissioner. So even on the most forgiving, the most generous, I should say, interpretation of plaintiff's argument, the county would have 4 months, at around 4 months, maybe 6, if you start with April 1st and end in the fall, September, to catch on to fraud or to errors like we apparently had here. So plaintiff's theory is that 303 changed the law, a statute that is just about correcting factual errors in the digest, actually created a new statute of limitations and cut it way down from 3 years to a matter of months. I submit, Your Honor, the plaintiffs are making 303 do a lot more work than this statute can do in the language that the legislature used. And it makes no sense.
Of course, 303 doesn't say you can't change it. It simply says you can't ding the taxpayer if you discover 2 years hence that that was the wrong exemption that you claimed, or whatever the issue is. It's not saying you can never fix it. It just means you can't go back retroactively to say, hey, for those 2 years that you benefited from this, we're going to need to collect on it. Their interpretation of that. I understand you differ, but I'm not seeing anything in any of plaintiff's argument saying you can't fix this. It's just the cost is borne, frankly, by all the other taxpayers than the one who benefited from it.
Yes, Your Honor. That's how we understand the case plaintiffs are making, and we submit that it just doesn't make any sense. They're reading way, way too much into a statute that's about correcting factual errors in the digest. And again, we submit what we have here is a wrongfully claimed exemption is at most an error of law. Your Honor, for these reasons, we submit that the county acted within the authority conferred by law 299A when it disallowed the wrongly claimed exemption and assessed the additional taxes within the limitations period. And all 3 of the years here are within the limitations period. For that reason, the plaintiff has failed to state a claim upon which relief can be granted. We ask Your Honor to dismiss. If the court has any other questions?
Well, at the risk of, I just not remembering what we discussed, and so we may not even want to go there, but how does resolving Gates affect Garrett?
Resolving Gates.
Let's assume for a minute you prevail. So I dismiss the Gates case. Are we back together again in a few weeks to handle a motion to dismiss on Garrett?
I think resolving Gates will resolve most of Garrett. There is the little piece of the 280 something taxpayers that where the look back went too far back. We have the Board of Assessors has reinstated their homesteads, and our understanding is that refunds are in process. I think that's the only conceivable part of Garrett that could still be alive theoretically. But the plaintiffs are taking an opposite position, something sort of against their own proposed class interests. So it'll be a
Okay.
different set of issues.
Well, I don't want to dive into Garrett other than I just couldn't remember. I know we had said, let's pause on Garrett and focus on Gates for a little bit to at least get through the motion to dismiss. Obviously, if I deny the motion to dismiss, both cases remain active and we'll need to figure out, is there a way, we can't consolidate them. I know I threw that idea out there once and then I thought about how you can't, it's not, so plaintiffs would need to decide, are they going Gates and Garrett or they want to stay one while they do another or what? Okay.
I think, Your Honor, resolving Gates, deciding the legal issue in Gates is going to decide 95 to 99% of Garrett.
There's clearly some spillover. It's just, it's not complete.
Yeah,
Okay.
it's tremendous overlap, but not complete.
Okay.
Thank you, Your Honor.
You bet. Okay. What's happening over there? I guess we don't know. Okay. What's happening over there? Okay. All right. Give me 1 second.
Absolutely, yeah.
Okay. When you're ready.
Thank you, Aaron. Good morning. Wingo Smith from Ms. Gates. You and opposing counsel have already had a fairly long discussion about the facts, so I'll go ahead and skip over that. Obviously,
Okay.
what I think the case brings into focus for the court is whether or not the county has a specific authority upon which it can act when it's taking these actions against homestead exemptions that it has previously approved. And it seems like that in listening.
When you say previously approved, I understand the words, but then that exemption expired, if you will, that's my term, upon the expiration of your client's mom. And so how is it taking action on an exemption that it previously, there is no exemption after Florine Gates passes away?
I think that's right, Your Honor. Under the statute, it is an automatic termination at that point. But the Board of Tax Assessors is required to place the approved amount on the return as well as all the assessments into the digest, and also then again when it finally bills the taxpayer. And so at that point, we understand, contrary, I think, to the county, that the county has a responsibility under the way that the modern code has been set up to review and approve those exemptions when they're going through that process. And it's shown, in fact, that it has the capability of doing that because it did it here.
Okay, you're saying it was approved, meaning even though there wasn't an exemption, it carried forward administratively because for 2019, 2020, 2021, we look at these assessments and there is the homestead exemption on there. That's not something your client generated. That comes out of the county's offices saying, here's your prospective tax bill. And it had the exemption on there.
Correct. And the approval language, as we understand it, comes from 48550, where the approved amount and the correctness of the exemption are to be placed onto the return. And as we understand it factually, that information is provided as well by the county after it issues the final assessment and the county tax commission when it issues the final bill, in between which it's provided on the digest.
Do Do you know the answer to my question about the digest?
I do. It's on there.
Okay.
The exemptions that taxpayers benefit from are listed on the digest in much the same way you would see in the assessment, in the sense that it provides not only the taxpayers, or the homeowner's name, their address, it provides the fair market value, the 40% of the fair market value, it provides the exemption amounts. There's also a proviso for credits down to the net taxation.
Okay, which I think makes sense, because what the county then does is say, with this digest, we see that we're going to have $250 million. We can build our budget around that. And if the digest was simply the assessed value of all these properties, I don't know how it gives you any guidance to create a budget. So I assumed, but like Mr. Delaney, I've never seen the digest. But it makes sense that it would have, if it's a massive spreadsheet, the entry would be either a parcel ID or the owner, and it will go across assessed value, exemptions, credits, et cetera. So that magic column in the end is, this is what we should see coming into our coffers if people pay their tax bills. So we know we can afford these new roads, we can afford these schools, or we can't.
And it's my understanding too, Your Honor, that when there's enough uncertainty in the digest, that is, when there are enough appeals that are pending as it relates to 48.5.311, the digest may not be approved until the appeals come under a certain level. So they have there's a certainty about what the corpus of the tax digest would be.
So then removing an exemption would be a change to the digest.
We agree that that would be a change to the digest. And we believe it's a factual error on the part of the county.
So that's what talk to me about why that's a factual error and not a legal error.
As we see it, approving an exemption for a homeowner for which they don't qualify requires a couple of different factual errors. One of which, in this case, was whether or not Ms. Gates was still the owner of the property. The other would be whether or not they still lived at the property as a residence.
Why is that not a legal error, that you are not entitled, you are legally not entitled to this exemption?
I think the final question of whether
there are always facts intermingled. It's never just, hey, there's a law that says, I mean, any law would be if you have an odd numbered house, you get taxed differently. Or if it's a farm, you get 5%. If it's a commercial business, you get 40% back when there wasn't something. So yes, there's always a fact involved, but in the end, isn't it because of A, B, and C, you are legally entitled to an exemption. And so that exemption goes in there. Now we're taking it out because you weren't legally entitled. There was a legal error as opposed to the factual error. It was 1234 Main Street, not 1233 Main Street, or something that would be factual through and through. There's no law applied. You had another 600 square feet in your basement. We didn't know about that. And so factually, we do this math based on the neighborhood you're in and this and that, and your assessed value goes up. There's not a law in that mix. Whereas here, some facts get pushed through a legal filter and something comes out. But if there's a legal error, that's what's being corrected. I'm not arguing with you. I'm just trying to see, you're saying it's a factual error.
Yeah.
And unsurprisingly, the county is saying au contraire. And more importantly, the legislature said factual errors, not just errors. And that's kind of unique. You don't see that phrase factual errors in lots of places. So that says to me, they were saying there's a certain kind of error, the correction of which should never inure to the disadvantage of the taxpayer.
Correct. We think that underlying the exemption are factual errors, and that's the issue that we would have with correcting the digest based on that error. Along with the property ownership, which is one of the three components of that, separately appears within the digest. So one would have to correct both of those things in Ms. Gates's case in order to correct the exemption amount or the ultimate value of the exemption. As I understand it, council is of the opinion that the Board of Fayette County the Fayette County Board of Assessors cases, that line of cases were subsumed into 303B But this seems to be much broad. 303B seems to address different issues and different concerns. And I'm not clear that an assessment in itself is actually a factual error. That appears to me to be one of interpretation.
An exemption or an assessment?
An assessment. That is a value, and let me back up one more step.
Right, because I thought we had
keep
moved.
using this term assessment. And I think that's because it has two different components within Georgia law. At least that's what the Georgia Utilities Companies versus Monroe County case explains to us. And that's whether a county had the ability to redetermine the fair market value of a utility, as well as assess the final tax for that utility. And the court said, well, those are two different functions that are both subsumed under the term assessment.
Okay.
And we have decided that based on the state law, because utilities return to the state tax commissioner, that the counties only have the second power in that case, rather than both powers. So I think that's why there's some confusion when we keep using the term assessment, because it means two different things.
Okay, well, let me tell you what I thought we had maybe all agreed, that the county could not next year look back at my house and say, you know, that house is a little nicer than we thought it was. And so we're going to reassess it, and you get your same exemptions and this and that, but when you push the math through, you actually owe another $100. That's not legal.
That's correct.
Okay,
You're absolutely,
we're agreeing with that.
yes, because
Well, let me finish. So we're agreeing with that. That's not what happened with your client.
we think what happened with our client is comparable to that. You have an ability to, when you take a step back.
In the sense that she owes money for past situations, but I'm looking at them. They did not reassess the value of her property.
We do not agree. I mean, we absolutely agree that there was no reassessment of the fair market value.
Okay, so whatever happened here did not run afoul of the prohibition of county governments reassessing the value of property retrospectively.
That's correct. I think what we see is a half a step more abstract than that, which is that when the county has a duty to take action within that tax year, it doesn't have the ability to go back to the prior tax year after it's made that final determination.
Got it. I follow that. And it's that second order assessment. In the end, you get a bill. Some people call that an assessment, which is based on an assessment of the value of your property.
Right.
And so that's maybe confusing linguistics. We should use a different word for what you owe, but it is what it is.
And in this particular case, in fact, when they did issue new bills to Ms. Gates, they called it a change in the assessment value. Like that was the reason code that they were using to assert new taxes for prior years.
But it was not, in fact, a change to, I'm going to call the valuation of the property.
Correct.
It was removing the exemption, and then you do the math, you lose the subtraction, and so you owe some money. And she certainly was being assessed, as in billed, for amounts that the county believes were owed but weren't paid.
Correct.
Okay.
I think at a fundamental level, where the disagreement comes down to is the authority that the county needs in order to support its policy. Our understanding of Georgia Utilities Company and the cases that stem out of that, including the Dean, the Denies cases, and the Morrison case, are that the county needs a specific authority upon which to base its decision to go back and change in those particular cases, a fair market valuation of the property. But there's no basis within those cases to say that the county would have, the counties in each of those cases relied on 299A to say, oh, no, we can go back and make these changes. And sometimes they called it a correction like they have here. Sometimes they called it a mistake, all trying to bring themselves under the banner of Barland, which was clerical errors were permitted to be corrected retroactively. But what we learned from those Court of Appeals cases is that without that specific authority, the county doesn't have the ability to infer a power that's not otherwise plainly in the statute. I understand that the language in 299A is broad, but in each of those cases, it was determined that it did not apply. And I think if the county's logic as to their power in 299A was correct, it would eviscerate those prior cases. that was the same method that they were trying to use in those cases to undermine the Court of Appeals decisions that said they couldn't go back and assess. But as we pointed out in our brief, that even if the court were persuaded to depart from that precedent, that you're not allowed to go back in prior years, 303A, we think, would limit those circumstances here in any case to those corrections that benefit the taxpayer. We would disagree with the county as well in the sense that, one, that we have abandoned any particular legal claim. We don't think that's the case, nor that the fact that Ms. Gates was billed $0 is important factually for her claim.
You're saying it doesn't matter that it was 0 or 10 or actually, I think it was $45, but I mean, for the county, it was 0.
Correct.
I don't think it's germane either. I think it just shows the degree of the reduction. But if she had gone from 10,000 to 5,000, I think that all of the county's points remain. I didn't hear their argument hinging on the fact that somehow because the balance was zeroed out, this case is different or is more alarming or.
Oh, no. I think they said that the fact that she didn't have any taxes owed to the county itself took it out of the theory under Georgia Utilities Companies or Morris in those cases.
I heard that Georgia Utilities doesn't apply because that said you may not reassess. If you said it was worth $100,000 before, you can't change it to 110 and then bill on that increase in value.
Yeah, well, I think they made both arguments. And so we just wanted to make clear that we didn't think that the fact that she paid 0 was at all relevant to the analysis here. As we see it, the fact that they made those approvals, put that information in, and thereafter tried to increase the taxes upon discovering that the exemption was there wasn't a qualifying homeowner for that particular exemption, puts it in line with denies in those other cases. And we look at those, and it doesn't. I think the other area in which we're finding ourselves sort of at loggerheads is this idea about whose responsibility it is, obviously. The statute, as we read it, doesn't put any affirmative duty on the taxpayer whatsoever to tell the county that the exemption has ended. There's just nothing in the statute that says you have a duty to do X, Y, or Z when this happens.
I'm not disagreeing with you. I'm trying to. I don't think I haven't read anything that says if you move into a property, you better make sure that you're not benefiting from someone else's exemptions. If you are assuming ownership from someone else, but doesn't the statute say if you want a homestead exemption, you better apply for one? You don't just get it because you live there.
That's correct. And once you apply, it automatically renews. That's the other part of the statute. That's the way that they've set it up. It automatically renews, as does the return to the property. And it's very few occasions in which someone would actually file well, I can't think of the word now. It's not report, but that someone would file a return, for property within Fulton County. Even when you purchase a property, for example, when we purchased a property in Fulton County, we paid the PT 61 tax and then began.
What's PT 61?
It's the property transfer tax. And so it's part of what you do at closing is there's this tax, it gets paid, it gets filed with the clerk of courts. Eventually down the line, it gets sent to the county. And that acts as a return for most people. So not even when you first purchase the property are you filing a return. It's all being done behind the scenes where the property owner isn't really involved in making those.
But if you buy a home in Fulton County, you need to, and you want to benefit from the homestead exemption, you need to apply for it.
I agree. I think what the issue would be is like in a case where you do all of that and Fulton County doesn't realize that they've applied the homestead exemption for the prior owner despite having received notice of the fact of the change in ownership, which could happen. That's
sure, but that would be a different fact pattern. And because you have the right to appeal, which was afforded to Ms. Gates could say, hey, I applied for a homestead exemption. You gave it to me, but for whatever reason, your system applied my mother's exemption. And because she was older, there was a greater benefit. But I did all the things I was supposed to do. It seems a little perverse that you're trying to bill me for 3 years of what I concede would be underpayment because you used the wrong homestead exemption. But I had no way of knowing you used the wrong one because it says HF 101F afterwards. I don't know which one that is. That's not this case because it doesn't sound like Peggy Gates ever applied for a homestead exemption. She just sailed forward under the aegis of her mother's. Is that factually, is that correct?
Pretty close.
Okay.
What we would say is this, is that once notified of the fact that she needed to apply for the homestead exemption, Ms. Gates then went twice to the tax commissioner's office.
She or her daughter did?
Both.
Okay.
She went with her daughter the second time. Her daughter went by herself the first time.
Mm-hmm.
And we're given incorrect information about whether or not she could apply for the homestead exemption and under what terms she could.
Because she was in, we don't need to get too far outside the record, but.
Because she was an heir who didn't have.
Got it. Because it was in probate at this time, or it wasn't in probate, but she didn't have, here's my deed to the property.
Correct.
Yeah.
So she was given two different sort of stories about why it was she couldn't apply at that point
Okay.
until she engaged counsel.
Right. And all of this was only after she got the letter in the mail saying, it looks like it actually was addressed to her mom. Hey, wait, maybe you shouldn't be getting this exemption anymore.
Right.
Okay.
And had the county done that in 2018 or 2019, that process would have happened then. She would have gone, would have probably gotten told wrong information, found a legal aid attorney to help her, and then gone through the process of making the application. And that's, not that it's important to the case, but that's how at least we got involved in this case. These are all cases that were coming out of legal aid because they were seeing this happen consistently to seniors in Atlanta, in Fulton County. That was happening time and time again. They were getting wrong information. They were having these large tax bills that were threatening their homes. Liens were being placed on it by private companies that then were accelerating the foreclosure process.
Private companies because they bought the county's tax liens?
Correct. Fulton County is one of the few counties, if not the only county, that participates or sells its tax liens to
Just
investors.
like this is Investa and these kind of companies?
Absolutely. That's correct, Your Honor.
All right.
And I think that the county recognizes the fact that the taxpayer doesn't actually have a duty to report in these cases because it calls it an implicit duty or effectively creates a duty, uses that kind of language around it in their brief at least. But even if they had a duty to report, which does exist for returns of property, right? So if you improve a home, not all improvements are visible to the naked eye. You could finish a
So
basement.
like the basement example.
Yeah, exactly. The Morrison case tells us that doesn't matter. In Morrison, two property owners, husband and wife, they bought abandoned property. Not abandoned, excuse me, a vacant lot. Upon buying the vacant lot, they then built a house on there, and they continue paying because it was a PT 61 case. They paid the return on what the prior return had been, which was a vacant lot. Years later, the county finds out, oh, actually, there's been a house built on here. And in fact, it's unreturned if you didn't tell us the fact that there was a house on here. So we have the right to go back and assess. And the court said, no, that's not how this works. You have a duty to assess. There's no, the fact that you didn't do it doesn't matter. The court doesn't require them to do their job, but it does say that it can't profit from it afterwards. And by taking back taxes that it could have prevented by acting timely or diligently.
But Morrison involves a scenario where the taxing authority sought to reassess the value of the property.
Absolutely.
Not to say you wrongfully claimed or traveled under an exemption to which you weren't legally qualified.
That's correct. It involves the fair market value of the property. In fact, all the cases here, with the exception of Harper, involve the fair market value of the property.
Yeah.
The Eckert case, which the county uses in its initial brief, referred to the fair market value of tangible property or inventory for a corporation. The Eckert Corporation appeared to be a rather shady corporation. It ended up in the Court of Appeals twice. trying to avoid a subpoena about what actual inventory it had, and then also then appealing the inventory that was reassessed, or excuse me, was assessed by the county in the case cited by Fulton County. What happened in that case, though, and I think which is distinguishes it in some ways from what we've been talking about, is that the court found because private property, or excuse me, tangible property like that, the inventory itself, is only assessed by the tax commissioner or by the tax assessor for the first time in an audit, that it couldn't be found to be in a reassessment as it would have been under Georgia Utilities Company or any of the cases that we cite in our favor. And so they considered this to be an initial valuation of that property. And in many parts of the decision, they in fact say it was unreturned entirely. Because when you don't report the number of aspirin bottles you have, and there's a certain number of aspirin bottles that don't get reported. And I think that takes it very much out of the realm of what we're talking about here, where there's been a prior approved exemption that the county, it automatically renews, the county sees it on there, it decides or doesn't decide then to, in its approval process, whether or not to check its validity any longer, and then continues on. And what we're seeing though, and here, at least in the way that we're, for our clients, is that the county is relying on the fact that it doesn't have to do, it's not taking that responsibility seriously for several years, lies in wait, then comes and hits taxpayers with large bills that in our cases would certainly have been different had they interjected and say, hey, are you still eligible for this years earlier? And it doesn't reflect the correct taxes because our clients would have been eligible for those tax exemptions at the time had they known that they could apply for them.
The lies in wait part, tell me your basis for framing it that way. Why does it, why would a county not right away seek to collect dollars that would have been real valuable that year, and they'd wait for 3 years? It's silly to wait 4 years because we know they can't go back 4 years, but the lying in wait part, you choose your words carefully. I'm just curious what prompted you to, or if that was more editorializing. Hold on one second. I'm confused. Should Mr. Leak or someone different? Today, if someone was coming in? Oh, it's not just Craig Daniels. That's right. So Calvin Ross. The email I got from Judge Emerson was that Emil is still on the fence, or is Emil now pleading?
They're closer to a plea now, but they were given until 12 to make that decision.
Okay. And the fact that the lead detective and the first responding officer have scheduling woes, but that's not going to grant a continuance, that's not resolving Leak for the state either? Huh. No, Mr. Ross should not show up if you can't be here. I'm hopeful you can be here, but if you can't, he does not need to work his way down here. Thanks for checking. Good luck. I apologize. We're juggling a few things. My afternoon calendar is criminal work, and that public defender is also potentially on trial in a different courtroom. I just needed to know I can't clone myself should my client not be here, since I may not be here this afternoon. And of course, he doesn't need to be here. So I apologize.
No, not at all, Your Honor.
But you were going to share with me, no, that was, look, I'm entitled to editorialize. I'm an advocate. Or if there is in the record evidence of laying in wait.
We think that that's one of the things that we need discovery for, Your Honor, is to show how this is operating. But it is clear, at least from the public documents that we were able to access, that anytime the county goes back and collects additional taxes from prior years, it takes a portion of what it collects from those contracts it has with the city. So there is a benefit to it for having done that, and including in that penalties and fees that they assess, which they otherwise wouldn't be allowed to take if it wasn't considered a delinquent tax. So in those ways, it increases that.
Sure. Penalties, is that interest, or it's penalty as in you didn't pay and in some code section, it says it's $100 if you didn't pay on time.
I don't have it in front of me, but my understanding was that it's both.
Okay.
There is a statutory interest that's applied retroactively to the date that they said the taxes would have been due. And then there's also a penalty, a fee that is for late payment of tax.
And does that fee, if it's in the record, go to the county, or does it go to Fred's delinquent tax AI firm that's making a lot of money off of this?
In theory, it goes to the county, who then may sell it to Fred's delinquent tax.
Okay. All right.
And in terms of the statute of limitations, I know that's something that come up a couple of times. You know, as we agree with council that Fayette County Board of Tax Assessors does talk about the pre-1985 statute, but later in that same decision, it talks about the post-1985 statute. And its gloss on that was that from the amendments to Title 48 that were enacted by the 1985 statute, let's see, as I quote, was not to confer any authority upon the board, the Board of Assessors, but merely to clarify and standardize the statute's limitation applicable to the assessment of additional taxes by the State Commissioner of Revenue. That's what it says in the decision. And when they cited Hormel later on, Hormel is another personal property case in which Hormel was disputing whether or not had actually asserted the 3-year statute of limitations under 299, using 299 and 249, and said that no, 3-year statute of limitation apply. You can't go back this far on our personal property. The court rejected that and said, first of all, there is prior precedent that says this doesn't apply to the Board of Commissioners at all. Secondly, it doesn't apply here because we consider the personal property to be unreturned. So neither of those cases stand for the proposition that 299A has inducted or it has embodied a 3-year statute of limitations from 48 to 49. I'd also say that when we look at 485 300.1, we see that in 2004, the legislature decided that it needed to insert a 3-year statute of limitations for personal property. And did so within that statute, which would have been unnecessary, again, if 299A operated in sync with 48249.
Okay. So what is your theory? That there is one, but it's unknown, or is there a default one somewhere in like Title I? If there is no listed statute of limitations, it's 5.
We don't have a theory on the statute of limitations because, frankly, it isn't central to our client's issue.
Okay.
It comes up in 2 different aspects within this case. It comes up within the county's determination of its authority as it relates to the 288 folks they're trying to remove from the
The overreaching, but whatever I don't mean to put words in Mr. Delane, but where they went back too far.
Correct.
Okay.
The determination that was too far is based entirely on that law.
That's 3 years.
Correct. On their authority of 299A, bringing in the statute of limitations of 48249.
Why would you not want to embrace the county's position that it's 3 years? Because if it's not 3 years, it could be longer. And then if things didn't go well for your clients, it could be that it's fine for the county to go back 5 years.
We certainly don't want the look-back period to be any longer than it needs to be.
You think it could be shorter than 3 years?
Correct.
Okay. It could be that 3 to 4 months that was described, which is a variable number between when a digest is proposed and it's approved, then that window.
Looking at basically within the same tax year.
Okay.
And I think that's what happens for assessments as well. Now, that isn't the case, obviously, if the assessment's never done in the first place. Like if the county, for whatever reason, isn't able to do the assessment, the timeline that's found in the statute about when those have to be done, April 1st, June 15th or July, whatever. If it's not able to do it in those timelines, they're able to go beyond that. That's the dates in there are not restrictive. They don't lose the ability to tax if they haven't done it in the first instance. But what we see here is that within the same tax year, after you've done that, after you've done it once within the same tax year, you don't get to go back and do it again. And actually, Eckert says the same thing. It talks about an attorney general's opinion. And it says, to the extent the Attorney General's opinion is meant to say that for personal property, you can't reassess, you can't go back and audit that personal property more than once within the tax year. It's approved. And so it falls in the same line of principles, the same logic that works with assessments.
What, and you may be getting to this and say, I'll get to it later. It sounds like there are people who are actively abusing the fact that it's complicated for a taxing authority to confirm eligibility, ongoing eligibility for the homestead exemption. And let's use Mr. Delaney's example of the gentleman who combined 2 units in the condo in Midtown and then jets off to New York and is renting it out and is benefiting from that. That's very, very different factually from your client. And let's assume, just for our discussion, that he knows that he should not be persisting with the exemption, but he thinks, I won't get caught and it's going to save me a bundle of money. And the county learns 2 years later, or they learn when they learn, and maybe he's been doing it for 6 years. Why shouldn't they be able to claw back some of what he knowingly and intentionally and thus wrongfully withheld from our tax coffers?
There's a whole procedure set out in the code that permits the county to go after people who have committed fraud. That's not going to change based on this lawsuit. It doesn't, in fact, affect this lawsuit at all.
How does it work?
What it is it makes it a crime for anyone to make a false or fraudulent claim for exemption under 44 and under 50, or make a false statement or a false representation in those cases.
But what is different about your client and this guy? Your client didn't qualify for the exemption she was getting because she hadn't applied. And so because people don't do returns, is it not a passive assertion that you qualify when you get your assessment and look at it and say, look at that, I got a homestead exemption. I'm going to enjoy that and pay $45. Or for Mr. Midtown, pay $27,000 instead of $32,000.
No, I mean, as far as the statute is concerned, it doesn't conceive of a passive false statement, of a non-statement or omission in that sense. And tax laws typically are strictly construed against the taxing agency, and so we think that that's, they could have included a penalty for that had they wished.
They could have included what?
A penalty for an omission if they'd wished. They did it with personal property. If you underreport your personal property, there's a 10% penalty that you pay under 299A-B, if I remember correctly. But they didn't do it here. They decided what fraud was going to be. It's going to be a misdemeanor. And they gave the county a bonus, if you want to call it that. They gave them an ability to collect. Once the person's been convicted, the person who's found guilty gets taxed twice or double the amount of tax otherwise to be paid. So there's an incentive or a built-in reason for which, if they believe there's fraud, that they can look to pursue that. We would say that's not the case here because there was no duty on our client to make any sort of affirmative claim about her mother no longer being alive. Obviously, she didn't understand that she had to reapply for the exemption at that point. And once it was brought to her attention, she did. She went back and talked to them twice to figure out what she needed to do, and eventually had to get counsel in order to be able to file the application with all the documents that showed her eligibility. There's a separate provision as well that makes it also makes it unlawful to make a false swearing as it relates to elderly property exemptions.
But we don't have that, and that's not here.
I don't believe it is.
Okay. The county cited a case, it's called City of Columbus versus Muskogee Manufacturing, and it's not a case quiz. That's not my point. But They rely on that for the proposition that laws that create exemptions from taxes are strictly construed in favor of the public. Because you point to cases that say, hey, basically tax laws are always construed to the disadvantage of the taxing authority and to the benefit of a taxpayer. And that
Correct.
seems to be the thrust of many cases. But is it different when we're dealing with an exemption?
I think it would be if we were talking about an appeal of Ms. Gates's eligibility for the exemption, but that's not what the court's looking at. There's a whole line of cases related to the what are called Freeport exemptions, which again is another personal property exemption. For whatever reason, commercial litigation tends to dominate in this area as well as others. But the county there in those line of cases, one of the first of which was TEC America Inc. versus DeKalb County Board of Tax Assessors, and that's at 170 GA appeals 533. And then there's several cases that spun out after that. It applied the strict construction to the county when it sought to remove a previously granted tax exemption. And it said, well, we're not dealing with the eligibility of the exemption, we're dealing with a waiver or forfeiture of the exemption in this particular case. So this is strictly construed against the county. It's not construed strictly against the taxpayer themselves.
But this was the same taxpayer. It was, you had an exemption and I don't know that case. Had facts and circumstances changed for that corporation, or the county was claiming that in its application to begin with, they put forth incorrect or false information?
That's correct. They said that they undervalued their inventory, much like was discussed in Eckert. So it was the same taxpayer from there was a return, so it wasn't a non-return property, but they undervalued the property. The county said you don't get the exemption. In one case, it was because of the timing issue. They said that they had filed it too late. The legislature at that point in time didn't have a waiver provision for Freeport exemptions, which is an important distinction here, and where I think this is a fair way of looking at this. The county seeks to be able to go back 3 years, but the exemption statute, such as it is, says that if you don't make an application for an exemption, by April 1st that year, you've waived the exemption for the year. So the homeowner who doesn't know that we're supposed to can't go backwards. There's an inability to do so. And we think this makes it so the legislature could have put it this way in order to make sure that there's parity between the two parties in terms of when they're going to be able to go back. But anyway, the legislature eventually fixed that. They added a waiver provision to the Freeport exemption. And then there were other reasons for which the county in different cases were trying to say that, in fact, you don't get the exemption any longer. And in that line of cases, they said, no, they've already qualified. There was already a qualification for the exemption. Now you're seeking to remove a prior exemption. That's going to be strictly construed against the county, not against the taxpayer.
Okay.
We also say that, obviously this is a motion to dismiss, as you've already noted, and so the county has to show there'd be no state of facts under which, no state approval of facts under which we'd be able to succeed, or our client would be able to succeed. And we just don't think that's been the case here. Finally, we've talked about Harper to a great extent. I don't think there's much to talk about. Your Honor already noted the distinction between the two. I'd say that in our modern statute, we still have a two-tiered approval system at the beginning for an application. So when you first apply for an exemption, it goes to the tax receiver who has to approve or disapprove it. And then they forward it on to the Board of Assessors. And then only after the Board of Assessors has made a decision can the taxpayer appeal the denial of a homestead exemption under 311.
And that first role is called tax receiver?
If memory serves, yes, it's called tax receiver.
Okay, I'm not doubting you. I just never heard of that. So when I moved a few years ago to a new place and applied for a homestead exemption, I see where it went. I'm sure it was online or something, but it technically went to function A, and that person does what before it goes on to the assessors to ultimately approve?
Yeah, the statute doesn't tell us exactly what they're doing in that moment. It just says the official receiving in this case. So it's no longer tax receiver. I apologize. That's the language that was used in Harper. But official receiving an application shall determine the eligibility and then transfer to the application to the County Board of Tax Assessors for the final determination.
Okay, but it's still you believe it's still a two-step process?
That's our understanding, is that someone within the tax assessor's office, likely staff would be my guess, is making that determination in the first instance, is looking at the application, determining, and then making a recommendation potentially onto the County Board of Assessors.
Okay.
And then right to appeal doesn't come until after the County Board of Assessors has, has denied the exemption. And that's what we see is, again, lining up with Eckert and with the other cases that we've talked about. Morrison denies, Georgia Utilities Company. We see in Harper the same thing. The County Board of Assessors hadn't passed yet on that particular exemption, and therefore it was an initial determination. They weren't going backwards and redetermining it. They were making their first determination, and the only one in our modern statute that you can appeal from. We don't think that's the case here, though. We think that now that the statute is set up the way it is, that once it is approved finally by the board, it automatically renews. Then the impetus shifts to the county to approve it, to review and approve it annually. Then when it's under 48,550, when it's putting that information back into the return, into the assessment, into the digest, and beyond into the tax bill.
In Harper, wasn't it several years between application handled by body one and disapproval by body two?
Yeah.
And nowadays, I didn't wait several years to get the green light on my homestead exemption. So whether that is just a functionary within a tax assessor's office or it's a separate place, the turnaround time is very different.
That's correct. Well, two things. First, I think it's because we have a professionalized staff that's working in the tax assessor's office now to do all that work. I don't know how many people were doing it in 1943. But I'd say the other difference too is, again, with those delayed cases, if the board delays its responsibility and it makes the first pass in certain cases, that's something that the Court of Appeals has said, listen, we're not going to say you can't do the initial assessment even though it's coming a year late. And that happened, I'm trying to remember now, I think it was, the case was Brown, but I have to go back and find the case site. But in Brown, essentially that's what happened. The state tax commissioner had rejected the county's returns for several years in a row. They reached a consent agreement. In the following year, the county was required, it finally got the digest approved. So it was like 1993, it got the digest approved for 1992. It assessed the taxes for the first time. That is the fair market value of the taxes and the final tax bills in 1983. And the court said, yeah, the digest wasn't approved. They had to go back and redo it. They're doing it, this is the first pass. So that's fine. You don't have to, if they didn't do the first pass yet, we're not going to penalize the county for having done that.
Got me. It's fine for them to have corrected an assessment because it wasn't actually even finalized.
In that particular case, I think the taxpayer was arguing whether or not they could assess it at all.
Okay.
Rather than a correction, quote unquote. Your Honor, we do have copies of the digest, at least for some of the years in question, if Your Honor would like us to tender copies to the court.
Is that like a 500 terabyte file? I don't even know what a...
It is huge. It actually causes my computer to crash every time I try to use it.
So that sounds like something I don't want. And I'm not doubting you, and Mr. Delaney can get up and say object to you taking judicial notice of what's in the tax digest. It was more out of curiosity. If the digest did not include the exemptions, then I was going to be less interested in what 303 said and the limitations it imposes. But it would make the digest not particularly useful to the taxing authority because it wouldn't show them an expected bottom line tax revenue figure either. So it makes sense that it's in there. I just was curious if we had that. How do you get a tax that, like, are you supposed to have that? Should you have said that in open court?
I think I'm fine doing it since we got it through an open records request
Okay.
to the state tax commissioner.
Okay.
Yeah, no, they permitted us to get those. We were surprised that they're sort of at their bulk and
they're county specific. You could get the Washington County Tax Digest, or you have the state digest that has each county within it.
no, we only have the Fulton County Digest.
That's probably the big one.
Yeah.
Yeah. Washington County might actually, might be able to just pop it in a TRS 80.
As it happens, it's split up into two. So there's an exempt, as in like the property itself is exempt, and then there's a non-exempt, which is homeowners and businesses. It's split into those two files, but the homeowners and businesses file is still also should include in their personal property as well, is enormous. So,
Okay.
well, Your Honor, if there's nothing further that you have from us,
Let me see from my review if I had other questions.
perhaps two other implications that we haven't discussed yet. One of which is, our concern had been for the 288 taxpayers that the same sort of issue with specific authority might exist. And we think it works on both sides. Not only does the tax commissioner, the tax assessor have to have the authority, specific authority, that is to go back and change prior year exemptions after they've been approved. They would also need to have that same authorization to go back and give money to people who had not asserted any claim to those funds. In this particular case, those are all going back more than 4 years now. So there's a real, or at least in the initial taxes. So there's a real concern about that. We don't want to put those taxpayers at further risk. And there was a second point that I had in my mind that just absolutely slipped out when we were talking about that. So I can wrap up.
Okay, well, I have two questions. One, are you saying that one of your arguments is that there is no authority for a county taxing authority, so the tax assessors, to remove a wrongfully claimed exemption retroactively?
Correct. Except for in the case of fraud, and we wouldn't disagree, and we don't believe they're part of the class, anyone who requested that removal.
Right, the Florida example, please get this off.
We assume this comes up more often, but obviously counsel would know better than us. But in those cases in which someone has moved and didn't realize that for whatever reason, the homestead wasn't removed from the property they left, and have tried to apply for a new homestead, and that homestead has been rejected by the new county.
Okay. So given your theory, what does 299A allow a taxing authority to do? If you can't do the things you're saying can't happen, is it just within that period before the digest is approved, the board can assess against the owner? And why would it say statute of limitations?
So I think there's two different things, well, maybe three even. So it covers a lot of different parts. The first part that it covers are properties that have never been returned, emphasizing the duty of the Board of Tax Assessors to ensure that everything gets into the digest in the first place.
What's an example when you say when you say a property that hasn't been returned? I know that in theory there's this fiction that we all return our properties each year, but sure. I would be, maybe I should be surprised. I feel like I would be surprised to learn that there are vast swaths of Fulton County that are not in the digest.
I don't think there are vast swaths of the Fulton County that aren't in the digest. I think it would happen if you subdivided your property potentially. you would have a parcel at that point that would come back unreturned until you filed something with the tax, likely the PT 61 in that. But if you're not selling to anybody at the same time, you may have to self-report. There's a separate parcel now.
So if I had 4 acres and I subdivided into 2-acre plots, then I would want to self-report that I only have 2 acres now, so you better not be assessing me for all 4. Wouldn't that be because if I didn't report that I only had 2 acres now, I'd be assessed for all 4 acres.
Correct. I think where you would run into that if you have a house on part of that lot is that if you're splitting it in that way, the other 2 acres probably wouldn't benefit any longer from the homestead exemption. So you'd want to.
Okay, so for unreturned property, which seems like a real small universe, 299 would apply there.
Correct.
What else? Why do we have 299A?
It's a bigger universe as well for, I think, for personal property, the unreturned property, obviously, because this 299A isn't limited to real property, obviously.
Okay.
But in addition, we're looking at taxes that have been assessed but not paid, which in.
So these would be the tax deadbeats. I got my tax bill and I didn't pay it.
Correct. That's very clear from the statute. I think that those are things that they're allowed to collect.
Mhm.
And usually what a statute of limitation is used for as well, to ensure that you're not collecting debts owed on taxes past a certain time for that certainty that we were talking about earlier. And just a quick side note on the certainty issue, we feel that the county's proposed reading of 299 could put future homeowners at risk. Say, for example, you buy a property on which you didn't know at the time that you purchased the property that the person who had sold it to you had been receiving an exemption that they weren't eligible for at the time. And the county then decides to go back and levy taxes for those 3 prior years. It could try to attempt to levy those on the person who previously owned the property, but it could also end up levying them on the property itself. And there doesn't seem to be a way in which you can protect yourself in that transaction. I mean, you're going to get, insurance, for the purposes of the deed record to make sure that there's been a lien search and all that kind of stuff. But there's no way for someone to go back in a position of a consumer, at least, or a purchaser of property, to go back and determine whether or not there may be lurking there a large tax bill.
So if I had purchased your client's home, Ms. Gates's home in 2023, I could well have been the one getting this unwelcome letter from the county saying, well, we actually think you owe a bunch of money.
Correct.
And I'd say, how is this possible? I didn't own the property.
Right. And they say, well, maybe it's not against you personally, but
Right.
It's as good as
You may be a great guy,
property.
but this piece of property is now going to have a lien on it.
Correct.
Hmm.
And so
Okay.
we think that's a problem as it relates to the certainty that families should expect when they're purchasing homes.
Okay.
I mean, those are 2 situations in which 299A clearly applies. The cases in which we've looked at and where 299A did apply, which would have been including Eckerd, also combined 299 with another statute. It was 299A plus 306A that permitted them to do the audit of the fair market value of the property that 299A authorized them to collect. There's no such 306A for exemptions. There's not a process by which the statute conceives for that kind of an audit for an exemption, looking backwards and trying to figure out whether or not an exemption property was undervalued or was unreturned. And so it's possible that it's an enabling statute that's combined with a procedural statute that tells the county then what they're allowed to do or not to do in that particular case. But we don't deny that the county has the ability within the same tax year, to deny the exemption for that tax year. And that's what should have happened here. And that once they discovered that Ms. Gates' mother had died, they could have denied the the exemption in that year. That would have triggered Ms. Gates to move. Either way, that would have caused Ms. Gates potentially to miss out on a year, depending on when it happened. She may not have been able to apply for the tax exemption that year when she found out, or the county may, if they had done it too early, they may have lost a year. But that's a lot less uncertainty than we're talking about with the county's approach. Largely, we think that the county has resorted.
When you say uncertainty, though, it seems like the uncertainty would be in the scenario you and I just discussed, where I could be unwittingly buying a piece of property that's going to have a tax liability that no amount of title search, deed search, et cetera, would reveal. What's the uncertainty for Ms. Gates? She should have applied for an exemption and she didn't. That wasn't an uncertain thing. She just didn't know it. But I'm not understanding the uncertainty she faced when her mother passed away.
Sure, that's fair. It's not that she was uncertain as to whether that was going to happen to her mother, I guess.
No, it has nothing to do with whether her mother would pass. It was the certainty that there's nothing unclear to me in the law that exemption ended when your client's mother passed. And so for there to be a homestead exemption on that piece of property going forward, someone had to own the property and occupy it and apply. And maybe your client qualified for the first two O's, certainly occupied it. And let's just assume for purposes of argument, she owned it, but she didn't apply. And that's not uncertain. So I'm trying to understand the uncertainty that your client faced.
Yeah, I think when you receive from the county, this is your tax bill. This is the assessment we've given you. This is the final assessment we've given you. This is the final tax bill that you've gotten. And then you make payment on that final bill, thinking that the county has done what they're supposed to do throughout there. Yes, I think that that's a certain amount of certainty that you're like, well, I've done what they've asked me to do. I did it. And I'm going to have to do it again the next year.
But one of the things they asked you to do was to apply for an exemption if you wanted to get the exemption, and she didn't do that.
They didn't ask her to do that. I mean, it's in the law. I don't disagree with it. It's in the law
Right.
that she has to apply for it. But it's not, she herself, because of the way the tax system is set up, is largely behind, largely works without the participation of the taxpayer other than to pay. And she wouldn't, in her personal capacity, she didn't know that there was something that she had to do in order to continue the exemption now that her mother had died.
I agree with that. I don't fault her for her lack of knowledge, but it was still her lack of knowledge and not something the county, they didn't hide the statute. So if you did a query online, you can't find that one, it's under seal. It was a knowable obligation, and it was her obligation, not the county's obligation. So again, I'm just pushing back on the uncertainty piece. Not the uncertainty of the unwitting buyer who bought from Ms. Gates 2 years later, but the uncertainty that someone situated like your client, what was the uncertainty she faced upon her mother's passing?
I think we can see, even though there is a requirement that the person apply for the exemption should they want the exemption in a given tax year, the legislature's choice of taking the return and application process out of the hands of taxpayers and making them automatic shifts that burden onto the county, onto the Board of Tax Assessors. And they're the ones who are responsible for approving the amount of the exemption, the existence of the exemption every year as it appears on all those documents that it sends out. And until they told her that there was something that she needed to do, there was no way not no way, but she didn't know that there was something else that she would have to do. And I think that tracks across the different cases that we have in different clients that we have in these two cases. You see somebody who is, going through the probate process and sends the notice that they're going through the probate process to the county and continues paying even after they've told the county that, and nothing changes. You have another person who's on the deed, and we've talked to other people who have been on the deed with the person who dies and don't know that they have to separately then apply because they're both on the deed and it automatically reverts to them. Who goes in, tells them what happens, told they don't need to do anything, and they come back out again. I don't think that's an unusual story here. The possessor of the knowledge, the entity that has the working knowledge of how this goes, routinely seems, at least if these clients' experiences are correct, routinely gives wrong information to people about what they need to do. And they ultimately have the responsibility for making sure this system goes right.
But isn't the remedy there then, an appeal? I came in, I asked you what to do, you said do X, I did X, and now you're telling me, whoops, sorry, X was bad advice, you owe us $10,000. What? Okay, I'm gonna appeal that assessment, and there's a mechanism to appeal. And I would hope in a, court of equity, and I don't mean issuing an injunction, but a court of fairness and reason, judge would say, that's ridiculous. If the evidence is that the taxing authority said do X and you did X and then they realized X was wrong, your tax liability is zero. You are not going to have to pay that.
Yeah. That appeal process obviously didn't exist in Fulton County until 2009, when the Marani class action.
Okay, but everything we're talking about here is
Right.
post 2009.
Absolutely. And, the way that we see it is that that is possible for some taxpayers. If they go in at the right time, then they may have an argument later on under a 311 appeal that, well, I went in, you told me the wrong thing. But it depends on when they go in. And especially when you're talking about homeowners who are going through, this probate process, which is long and not easily understood in and of itself. The last thing they may know to do is like, well, now I need to go into this other thing and talk to them as well about this other problem that I may be having or may not be having. I don't think I have a problem because I'm paying what they asked me to pay each time that they ask me to pay it.
Okay.
In this particular case, obviously, the reason why the 311 appeal wasn't necessary, or even in the other two cases why the 311 appeals were necessary, is because the taxpayers ultimately pay the tax to avoid foreclosure, which happens to thousands of families. We see the legislature as taking a different path than the one the county has sort of placed on this case, and placing the onus to act on the county rather than on those taxpayers. Once approved, I think what we're showing through here, once approved, the county cannot retroactively increase property taxes on homeowners, no matter if it discovered an improvement to the property, didn't know it existed at the time, undervalued the property's fair market value at some point in time, or we would say as well, if it failed to remove the exemption in a diligent manner. So we would ask, Your Honor, because there's still some facts to get out, the fact that there is no specific authority that permits the county to take these actions within the tax code itself. There is no 306A for this. Without that specific authority, we'd ask this honor to dismiss the county's motion to dismiss and allow us to continue then with discovery in this case.
All right. Thank you, sir.
Thank you.
Few minutes to respond.
Understood, Your Honor. And I will not go over any territory we've already gone over together. I'll just respond to a few points. The tax code unhelpfully does not contain a definition of what the tax digest is, so the law doesn't answer your question. The closest we get is a definition of certified tax digest, which is in 48.532.1A2. And the certified tax digest is there defined as the total net assessed value. So after all exemptions are applied, and then it's to the entire county. So it seems that if we look at the notice of assessment, the certified tax digest is essentially the bottom line after everything is built into it. Even granting plaintiffs that the exemptions are included in how you get down to that bottom line in the digest, what we have here is a legal error, not a factual error. And 303 is notable in that it provides, it's only pertaining to factual errors, not legal errors. What the plaintiffs want to do is to take the undefined term tax digest and have it apply so broadly to things such as these legal errors that it swallows 299A's 3-year statute of limitations, which is also brought in from 48.249B. This is, Your Honor, the magic bullet theory of statutory construction. They're having this statute do something that on its face it does not. Excuse me. And now today we've heard for the first time plaintiffs realize a matter of months is silly. And so now it's within the same tax year. That's what I just heard. Where's that in the statute? That's not anywhere in the statute. We also heard, Your Honor, for the first time today about a hypothetical purchaser who's purchasing from the fellow who owns the Midtown condo. And then they're going to get hit with a big bill that they're not expecting and that they had no way to do any due diligence around. You maybe could do that due diligence if you tried. That's not this case. And if they can find a plaintiff in that situation to be a class representative and litigate this case, that case.
Let's not invite them to bring another class action case because it would come to me as a related case. So that's a bad idea.
I'm not afraid of it, Your Honor, because if and when that day ever comes, I will have an explanation for what the county's policy is that avoids that situation. And I'll submit, Your Honor, that day is never going to come because our policies and procedures are in place to address that situation.
Okay.
Your Honor touched on this, I think, but I want to get to it explicitly. Taxpayers are charged with knowledge of the law, and they're charged with knowing about these return provisions. And they're charged with the fact that, or they're charged with knowledge of the legal framework that we've been discussing today, wherein Ms. Gates was falsely returning her property for taxation for years. Your Honor also mentioned this, and I do want to highlight it for a moment. We heard today that the plaintiff's way to distinguish the Harper versus Davis case is that, well, in that case, it was only a conditional grant of the exemption, and then you had to go, as Your Honor said, to body number 2 before it got finally disallowed by the assessors. Well, Peggy Gates is on worse footing than that. She has never had an exemption granted to her because she never applied, at least not until 2024. And on the point that we heard about she was just paying what she was asked to pay, well, she was asked to pay 0. So there's not a lot of equity in that. And more importantly, she was getting those notices of assessment every year, and they weren't in her name. She was charged with knowledge that there's a problem here. I heard today, Your Honor, that OCGA 300.1 adopted a 3-year statute of limitations for personality. And the hypothetical question was asked by my adversary, well, why would they have needed to do that if 49B already has that? Well, the answer to that is that 300.1 does create a 3-year, but it's 3 years measured from a different place. 300.1 for personality is 3 years from the date the tax bill was paid, which is different from 3 years from when the return was due. That's 49B. 303 on their reading would apply to tax fraud. There's no exception in 303 that carves out tax fraud. That's part of the problem here. Tax fraud would be a factual error in the digest on plaintiff's reading of this case. And I don't see how they're not trying to defend tax fraud. They're conceding that ground at least, right? But you can't square that with the language of the statute on their construction. And Your Honor, finally, you picked up on the point. Exemptions are strictly construed in favor of taxation and against the exemption. And that's what we rest on.
Question. Mr. Smith did an effective job of pairing, these aren't his words, sort of an enabling statute that says it's bad if you do this in the tax area within 299, and then you're not supposed to do this in 299. And one of his arguments was, but there isn't anything that says you've got this affirmative obligation to cast off inherited exemptions when you buy the property and seek only your own. There's not he wasn't identifying one, doesn't mean there isn't one. But his point was there's not a statute out there in the tax code that says, here are your obligations, taxpayer, vis-a-vis the homestead exemption. And a violation of that linked with 299 is the kind of thing that Mr. Smith said, now that would be harder for us to be working through right here, but we don't have it. It's basically the county messed up, not Ms. Gates. The county messed up by perpetuating this exemption that plainly didn't apply to Peggy Gates. It expired upon the death of her mother. And so it should have gone away. Shame on the county. It's not exactly how he put it, but that was sort of like the whole thing about they're laying in wait to pounce. And I get it. But the point that piqued my interest was, where's the corresponding thou shalt or thou shalt not?
Thou shalt not commit the crime of a misdemeanor false tax return. And the law here is deeming Peggy Gates, when she starts paying the taxes on 412 Holly Street in 2018 after her mother dies, or not paying the taxes, depending on which line of tax you're looking at, is deeming her to file that return every year, claiming that same exemption. And that is a false return.
When you accept passively the notice from the county saying, here's our assessment, and it includes it, great, I'm gonna stroke a check for $45. That is your acceptance of that return. And each year you're paying that, because there was a little bit she owed just to the city. That is basically saying, yep, that's accurate. That's my property, and that's the status of my property. That's the value. I'm not challenging the valuation, and you've got my exemptions right. And so I, as the taxpayer, am saying that's correct.
It actually happens under the law on April 1st, when if you don't come forward and file an affirmative return, you're being deemed to be filing a return claiming the same exemptions as the prior year, exemptions you were not entitled to.
And it's a case that says that, or it's a statute that says that?
Statutes.
And what's that?
One of the ones we handed up,
Then I have it.
4520A1. The end of which reads, each such taxpayer shall also be deemed to have claimed the same homestead exemption and all personal property exemption as allowed in the preceding year.
Okay. Last question then. How does that theory interact with the facts of this case, which is it wasn't Peggy Gates's assessment, it was her mom's. That was the name that was on there.
That's the problem. And that's the problem that the taxpayer has that we don't. It's not the county's responsibility. When she's being deemed to return the property claiming the max 70 exemption again,
Okay.
it's a false claim.
And this isn't so much Peggy Gates, it's property, this piece of property, because we've had some back and forth about, well, does the county stick it to the person or the property? And this parcel had for a number of years, no returns. And so there was an adoption of the county's document per 48520A1 that was facially invalid. Look at the name of the taxpayer. That person's deceased. And that's where then you hook that into 299.
Yes.
Okay. All right.
Thank you, Your Honor.
Thank you. So we'll take all this under advisement. I will let you both sides know that I very much reserve the right to reach out with questions or, hey, could you give me this case citation? You kept talking about Eckert, and Eckert I've got a citation for, but you talk about a case, could I have that citation? And it may well also get you all an order sooner if what I end up doing is having Ms. Niles reach out to both sides saying, here's what the judge has decided, you should do a proposed order. And if that's Mr. Smith doing the proposed order, Mr. Delaney will have an opportunity to redline it, not to say, no, you got to grant the motion. It wouldn't be that at all. It would be, it was 7, not 4. So to flag what you think is a factual mistake. And if you agree, then you can accept that change. If you don't, hey, it's my order in the end, and I'll figure out, is it 4 or is it 7? The level of, to me, is complex and obscure because I blessedly don't move around in this space a whole lot. And so that increases the likelihood that when Ms. Niles and I confer and we think we sort of figured out what's going on, that we seek the assistance of the side that prevails on this one to do a proposed order. But maybe not. We'll see what happens. Okay. Mr. Smith, anything else at this point on behalf of your client?
No, Your Honor, thank you for your generous amount of time today. We appreciate it.
It is well earned. These two cases have been stuck for a little while. I appreciate your patience and your client's patience with that. Mr. Delaney, anything else on behalf of the county?
No, Your Honor, thank you very much for your time this morning.
You're welcome. Also, Ms. Ringer, anything from the city?
No, Your Honor.
City's good? City should be good. That's where more of the money goes anyway. So, all right. Thank you, everyone, for your time. Stay warm, and we'll be in touch. I'm going to be here for a minute, so you don't have to stay like that. I'm just standing because it's been a minute.